10. Yes, 2024. Lord, Her Ladyship, Lord, of the Andhra Pradesh High Court. Lord, this arose in the context of a regular bail because there the arrest happened, but Lord, same principles would apply for the anticipatory bail would be my respectful submission. Para 7, the ladyship may only notice there, my lord, the petitioner was 21 years and the victim girl is 16 years 5 months. My lord, then next para 8, recently a coordinate bench of Delhi High Court. My lord, this is a different judgment from which I placed, Mahesh Kumar. My lord, that is quoted Delhi High Court. The prosecutrix and the accused herein might have made a mistake in the affairs of the heart. However, the teenage psychology and adolescent love cannot be controlled by the courts, and therefore the judge has to be careful while rejecting or granting bail in such cases, depending on the facts and circumstances of each case. This court also observes that the attitude towards early love relationships, especially adolescent love, has to be scrutinized in the backdrop of their real life situations to understand their actions in a given situation. The teenagers who try to imitate romantic culture of movies and novels remain unaware about the laws and the age of consent. My lord, then Bhagwan Singh judgment is cited. If I may just invite my ladyship's attention to page para 11.
Yes.
Coming to the case on hand, the victim girl is a minor. Her consent is of no value in the eyes of law. According to her, she was in love and she voluntarily left with the accused, married, had physical intimacy. In the peculiar circumstances of the case, it's clear that after consuming poison, the victim called the accused and informed him that her family was against her wish to marry him. The conduct of the accused as seen from the complaint is vivid, that on coming to know that a case was lodged against him, he dropped the girl at her parents' house, which would indicate that his intention was not otherwise dangerous. The complaint would further show after studying class 9, the girl dropped out and was staying at her house. The age of the girl is subject matter of a full-length trial now. But why I refer to this particular paragraph is, the ladyship sees 7th is according to the complaint itself, the relationship broke. 13th, the boy calls the mother, informs the mother, calls the father, informs the father, please ensure no danger is done to the daughter, protect her because she is threatening to commit suicide, take necessary steps. Assuming that this call, and it was made, my lord, because the messages would bear this out and investigation would reveal more details. It would show the conduct of, my lord, this person, that he had no intention of trying to do something, run away, to wash off his responsibilities. I've placed, my lord, only some part of the conversations that happened. Now, your ladyship also sees the conduct of the prosecutrix. But from the chat, limited chat, and I didn't want to place more, my lord, because this matter is being heard everywhere. And maybe, my lord, the next date, or there may not be a next date in this case, but whenever anything we have to do, we'll try to request the court to do it in camera. But my respectful submission is, the conduct of the prosecutrix, if she, my lord, was in a position where, my lord, she was going out, meeting people, staying for 3-4 days, nothing wrong, my lord, because parents trust their children, they give the children, my lord, the freedom. And we, my lord, when we do that, we trust the children only after we feel they are capable of taking some independent decisions. But I am not making any allegations, my lord, I just want to be very clear. I am saying that even according to the parents, when they're allowing the child to go out for 3 nights, 4 nights, 2 nights, they trust the child and they know the best. They are the best judges. I am now, my lord, relying on the parents' judgment of the child's maturity, where they think the girl can go and stay out for 2 nights, 3 nights, or 4 nights. But if the parents have sufficient confidence in the maturity of the girl, and the girl is not lesser than 17 years, my lord, even according to their own case, if the girl, my lord, was in a relationship which the complaint refers, and if the relationship ends in a breakup as the complaint says, and if the complaint thereafter says that this breakup, her ending into a relationship was induced by a false promise of marriage, it may be a case of cheating, not penetrative sexual assault, under POCSO. In fact, I must, yes, so, my respectful submission is, in the totality of these circumstances, where the law itself, A, did not prohibit the grant of anticipatory bail, B, if the facts and circumstances, and I have placed several orders of the Supreme Court granting interim protection which have been confirmed under section 6, and where there are several other judgments of the court Not Law Commission's report, not I'm not referring to the recommendations, but I just want to place it where the Law Commission refers to various high courts lamenting, my lord, this wrong application of POXO. I'm not even using the word misusing. And Law Commission therefore recommends. So, my lord, the recommendation may not have been accepted, law may not have been amended, but the Law Commission noting that several courts across, my lord, and the several courts, as I mentioned, my lord, would be Madras High Court, Kerala High Court, my lord, Karnataka High Court, Madras, I mentioned Madras High Court, my lord, Allahabad High Court, Bombay High Court, my lord, Guwahati High Court. I have all these judgments. Where my lord, the courts have lamented, I just need to show the Law Commission recommendation with regard to the High Court speaking of.
They are all not necessary for.
Very well. So, my lord, my respectful submission is, this is a matter that may require investigation. I am not asking for quash. I am only praying for grant of anticipatory bail. But if anticipatory bail is granted, I will readily go join investigation, assist. If suppose after my assistance, after deeper investigation, but it is eventually found that I have to be found guilty of some offense, the punishment would follow. But suppose if I am taken into custody and eventually if I am able to show, my lord, that this is maybe, my lord, an incorrect application of POXO being applied against me, particularly, my lord, those more graver sections, then my detention being caused, my lord, will become irreversible and it will be harmful. So, my lord, my respectful submission to your ladyship's kind consideration is, in the facts of this case alone, in the circumstances of this case alone, taking the complaint as was drafted with full legal advice, my lord, no serious offense was originally made out. 161 statements, my lord, that may have been recorded. The learned PP may assist your lordships, but your ladyships may take it that whatever they are saying post 8th May would be for the purpose of trying to frame me in a more strong sense that I'll come under the threat of. And my lord, they have a grievance. They have a motive to improve and punish me because they feel wronged. Your ladyship sees the complaint itself, they feel wrong. So they have a motive, my lord, trying to go after me. If your ladyships are able to see that, my lord, I would respectfully pray that anticipatory will be granted to my client. Any conditions, my lord, last submission I'm making, even if, my lord, in some cases, my lord, court directs, my lord, that there must be some reports made to the court monitored investigation, my lord, by any condition where I have to go and appear on almost on an everyday basis, my lord, let me do it. Let me give any assistance they may need. I am fully willing to subject myself, my lord, to this investigation. I just need, my lord, to ensure that I am protected for the purpose of going and appearing and giving everything that they need. Because this is a false case filed against me. But I am deeply.
Anybody a diabetic here?
My lord, I got the instruction, my lord. My land senior counsel yesterday argument, today argument, my lord, is seeking the anticipatory bail in POXO case. Definitely is not entitled. My lord, kindly see, my lord, my land counsel, my lord, submitted before this honorable court. Improvement is there, my lord, nothing. Even first complaint, my lord, victim daughter, my lord, victim, my lord, mother also filed the complaint on 8/5. Even, my lord, page 17, my lord, kindly see complaint, my lord. My land,
he read out in total.
yes, skip, my lord, where he was skipped the land counsel, skipped the word. It only 4 lines without my lord reading. Kindly go through the, my lord, even it attract the, my lord, 5 and 6 POXO Act. Page 17, my lord. My land friend skipped the words in order to.
Para 6.
Yes, my lord. Para 6 last 4 lines. My lord, definitely, my lord, it attract the, my lord, 5 and 6 POXO Act. Apart from that, my lord, my instructions would be.
No, you say that 5 and 6 are attracted there.
Yes, my lord.
What is 5?
Even first complaint itself. What I want to. My lord, even 161.
And then if it attracted, then why did you not add it?
My lord, even my land friend time and again saying that it is an improvement. My lord, adding
initially, okay, let it not be.
my lord, even 161 statement.
When you are saying that, these recitations in para 6.
Even my humble
attracts for 5 and 6. You should have added.
Even words, my lord, even my lord, FIR is not an encyclopedia. My lord, IO having the power to, my lord, either delete the, my lord, accused or added the accused, my lord, he is having the absolute power. My lord, subsequently, after, my lord, taken into, my lord, statements from the victim itself, then, my lord, added the section of law.
Okay. Now, what is that statement which
My lord,
you
kindly
need to
see.
add?
Milad, victim statement, Milad, page number 15, 14, Milad.
This is the mother of the victim.
16, Milad, 16 and 19.
14.
9th, Milad, 9/5/2026 was recorded by the Milad sub-inspector. Yesterday, my land friend stated before this honorable court, Milad, IPS officer, lady IPS, not at all correct. Only sub-inspector Milad, 16, Milad. Lordship got it, Milad. May I permit to read out?
Yes.
నేను బాధితురాలని పరిచయం చేసుకుని ఏం జరిగిందని అడగగా మా తల్లిదండ్రులకు ఇద్దరం సంతానము.
You can leave out all those things and
Milad,
come to the
even-
relevant portions.
Even narrated the Milad in detail, Milad, apart from the her mother complaint.
Yeah.
Milad, even middle Milad, only మా తల్లిదండ్రులకు హైదరాబాద్కు వచ్చి సుచిత్రాలో సోన్సో నందు ఉన్నాము. నేను 10వ తరగతి వరకు డిఆర్ఎస్ నందు కోంపల్లో చదువుకున్నాను. తర్వాత ఇంటర్మీడియట్ నిర్మల్లో ఓపెన్ యూనివర్సిటీ నందు ఆర్ట్స్ హెచ్ఈసి తీసుకొని చదువుకుంటున్నాను. తర్వాత జూన్ 2025లో లోకేశ్వరరావు అనే ఫ్రెండ్ ద్వారా పరిచయం అయ్యాడు. జూన్లో నాకు సోన్సో నా సస్పెక్ట్ యొక్క అకౌంట్కు బండి సోన్సో పర్సన్ 23 years స్టూడెంట్ సోన్సో అనే వ్యక్తి నాకు ఫ్రెండ్ గా రిక్వెస్ట్ పంపించినాడు. నేను బండి సోన్సో పెట్టిన ఫ్రెండ్ కు రిక్వెస్ట్ నాకు హౌ హీ వాజ్ ఇంట్రడ్యూస్డ్ Milad, he was narrated. Milad, kindly see next, Milad, in order to save the
This
time.
is not in dispute at all that there was friendship or relationship or introduction.
Milad,
That is not in dispute at all.
According to
So let us leave.
my humble submission,
Come
according to
to-
first complaint, according to second complaint, definitely the contents Milad mentioned by the victim, there absolutely there is a Milad penetrative sexual is there.
Come to that portion
Milad.
or whatever you think relevant. Just about her
Yes, Milad.
introduction about herself and all that may not be relevant there. That's what I'd say.
Milad,
ఇద్దరము మా యొక్క కామన్ ఫ్రెండ్స్ తో కలిసి రెస్టారెంట్ కఫే
page number 17 Milad, concerned para,
ఎస్
middle Milad,
ఐ థింక్ హియర్ ఆల్సో
page number 17, 161 statement, Milad, in respect of victim girl, page 17, Lordship got it? Middle.
you should
13th
read the
November
last,
2025.
you should read the last lines of page 16 also.
ఎస్ మిలట్, నాకు తెలియకుండా ఎక్కడికి వెళ్ళొద్దని, నా ఫ్రెండ్ను కూడా కలవద్దని రిక్వెస్ట్ చేసేవాడు, రెస్పెక్ట్ చేసేవాడు. తర్వాత గోల్డ్ పేజ్ అపార్ట్మెంట్ కి నానక్రామ్గూడ ఎయిర్ బ్యాండ్ ఏపీపీ ద్వారా సోన్సో అపార్ట్మెంట్ ను అక్టోబర్ 2025 నాడు డబుల్ బెడ్రూమ్ అపార్ట్మెంట్ బుక్ చేశాడు. తర్వాత అదే రోజు నేను సోన్సో మోక్షలం కలిసి వెళ్ళినాము. తర్వాత మేము కలిసి పార్టీ చేసుకున్నాము. ఆ రోజు సోన్సో ఐఎమ్ స్కిప్పింగ్ ది నేమ్ తీసుకున్నాడు. అదే మత్తులో అర్ధరాత్రి నా దగ్గరకు వచ్చి నా యొక్క నెక్ పట్టుకొని నా నెక్కును సోన్సో అన్నాడు. తర్వాత yes,
you are reading this
Milad, kindly see Milad, next Milad. Of course Milad, there is a clear word see there. Milad, 13th middle Milad, 13th November 2025. Next after 5-6 lines, 13th November 2025, మా పేరెంట్స్ లేరని తెలుసుకొని, Lordship got it? Middle Milad, same page 17, same page, left hand side, 13th November 2025.
left hand side. Yes.
13th November 2025, మా పేరెంట్స్ లేరని తెలుసుకొని మనము స్లీప్ ఓవర్కి వెళ్దామా అని అడిగినాడు. నేను వద్దు, మనం ఇద్దరమే అని అనగా, లేదు మనతో సోన్సో కూడా వస్తారని చెప్పి మా ఇంటి దగ్గరకి వచ్చి నన్ను తీసుకొని లక్స్ ఫామ్ హౌస్ తీసుకుని వెళ్ళినాడు. అక్కడ నాకు అర్ధరాత్రి ఆల్కహాల్ కలిపిన డ్రింక్ కు నాకు బలవంతంగా ఇచ్చాడు. అతను కూడా ఆల్కహాల్ సేవించి నా యొక్క సోన్సో చేసినాడు. నన్ను కూడా దిస్ ఇస్ ది ఆల్ ది She's narrated everything, my lord. The reason for skipping, my lord, it is not fair to read the open court, my lord, all these things.
No need of reading, yes.
Yes, my lord. Next also, my lord.
So this is the statement of the girl on what
Yes,
date?
my lord.
On what date?
My lord,
It is on
9th, my lord. 9/5/2026, my lord. Recorded. My lord, the next page, my lord, 60, page number 20.
Yes.
My lord, after recording the statement from the victim, my lord, section of memo was filed, my lord, same was altered. My lord, kindly see page 21, my lord.
Yes.
Page 21, my lord, reflects, my lord, initially she was studied, my lord, victim girl studied 1 to 6th class at Bhairava, my lord, 1 to 6th class, my lord. According to the 21, my lord, disclosed that her age, my lord, 12/8/2010, right hand side, my lord.
Yes.
My lord,
So
page
10th
20,
class SSC memo also shows
yes,
the
I,
same
my lord,
date.
I filed. My lord, page 22, my lord.
Oh, but SSC certificate shows something else.
Yes, my lord. There is a two dates are there, my lord. Finally, my lord, according to investigation, my lord, 12/8/2008, my lord, 8 is the correct. My lord, page number 24, kindly, my lord. The 10th class memo, my lord, marks memo.
12/8/2008 is the correct one.
8 correct. Reason would be, my lord, the IO, my lord, inquired with the date of birth certificate, kindly see 25, my lord. Date of birth certificate given by the GHMC Hyderabad. My lord, she was given a birth at Perenda's Hospital, Hyderabad. Our IO, my lord, went to the Perenda's Hospital and verified the record, and it is found to be correct. So finally, my lord, her date of birth 12th August 2008.
Yes.
Therefore, my lord, is
So even if it is taken 12th August 2008, she's still a minor?
yes, my lord. Yes, my lord. My lord,
What would be her age?
now as on today, my lord,
As on the date of, we will take it in 31st December.
17 years, 3 months, my lord. 17 years.
17 years, 3 months and 15 days.
17 years and 3
The
months.
last date of
Yes.
But 2 dates are there, whatever the dates taken, my lord, even 2008 correct date of birth taken also, my lord, she is a minor. Therefore, my lord, is a FOCSO Act, my lord, is not entitled to get any bail, my lord. Therefore, it should be dismissed, my humble submission.
Yes.
May it please your lordship. Well, two strong points were raised by them, my lord. The first and the foremost was, my lord, POSCO would not get attracted as a victim is not a minor as defined under the said act. The second point what they raised was that, my lord, assuming even POSCO gets attracted, section 5(1) punishable under section 6 has no application, as the sections which are applicable are all punishable with less than 7 years, which have been originally registered in the FIR, and thus is entitled to a notice under section 35(3) of the BNSS, my lord, which is equal to 41A of the old act, I mean the CRPC. And then interim protection, which now they are not claiming, my lord. So in my written arguments, my lord, I've just mentioned, which I'll pass it on as a brief note I've made.
He has argued the criminal,
No,
both
we are, that's what, my lord, we have, my learned friend said that he wants to argue the anticipated bail application. So therefore, even I agreed that we will conclude it today itself. There is no point now further postponing it. And I don't want to go into the technicalities of that, my lord, and waste the precious time of this honorable court.